We'll be looking at those judgments and the different ways people are interpreting them. My guest is Barrister Tunde Kolawole, of course, a legal practitioner. Thank you for coming to the studio to discuss
Good morning. Thanks for having me.
All right.
Let me say good morning to people listening to us this morning.
Okay. The common questions Nigerians are asking is, yes, the Supreme Court, but the justices of the Supreme Court, are they Nigerians? Do they live in the country? Do they have television sets? Do they watch them? Do they know what is going on? Common questions of Nigerians, really.
Yeah, that's a very good one. Let me say this. In common parlance, people say that people will get the kind of government that they deserve. You can also say that of any court in the land, whether it be the magistrate court, the High Court, the Court of Appeal, or the Supreme Court. You will not expect these courts to rise above what is ordinarily happening in the society as a whole. If we have a society that is corruption-free, if we have a society that is committed to fair hearing, if we have a society that is a society that is responsive to the yearnings of the ordinary person, before you and I, we are likely to have a court of law, whether it be at the Supreme Court, the Court of Appeal, that will reflect what the aspirations and wishes of the people are. What I'm trying to say is that the judiciary you get is a reflection on a mirror of the overall society that we do have. The rottenness that we have in the society is likely to also permeate what is happening in the judiciary. And if you also have a society that is decent, that is corruption-free, that is committed to the welfare of all, then you can also be rest assured that you have a judiciary that will reflect all of this. So, as regards what the hues and cries have been on television, on radio, on TV, and what have you, let me say this, that most times the justice system, especially the judiciary, in any of the different parts of the court and all that, actually get themselves influenced by what the ordinary folk is saying in the street. In fact, most times I'm aware that when there are controversial cases and all that, the men on the bench always, as much as possible, try to insulate themselves from all this media of mass communication. Most times, some of them don't read paper, and when they read the paper, issues that concern cases that are before them, they try as much as possible to shy away from those things, so that those decisions, so that what is being said in the media does not at the end of the day influence whatever decision that might come up with at the end of the day. And it is a common logic that as much as possible you want to refrain from the den. Now, be that as it may, let me also say this. Why are people not too comfortable with some of the decisions that have come out from the Supreme Court? The answer can be said to be neither here nor there, in the sense that when you look at decisions that have come out from the Supreme Court in all the governorship election, or even for almost of all the political cases that have been before then, you find out that it cuts across all the different political claims and parties that you do have in the country. You have most of the APC governorship petitions that are taken by the Supreme. All the decisions have been affirmed. All the governors have been asked to continue the different. All that also came from the PDP and all that. The Supreme Court has simply also affirmed all those decisions. I've also said all the governors should continue. But there are different
scenarios, really, especially that of the peculiar case of River State.
Exactly. I was going to get there. Yes, I was going to get there. Don't forget that I've said most times our court always want to shield themselves away from what is happening in the media. But you are not far from hitting the nails on the head in what you have said, in the sense that the election monitoring groups, the international bodies, most of the different embassies and all that have also monitored the elections. Akwa Ibom, and then I think, which is the other, the Cross River State and what have come out with very stinging indictment of the processes that took place in all those places. And you will also find out that the lawyers and the petitioners who approach the election petition tribunal in all these states that we have mentioned have striven very stridently to prove their case to prove their case before all the different elections petition tribunal in those, especially those 3 states. It is based on what they were able to prove. It is based on the evidence that they were able to lay before the court. That was why the Election Petition Tribunal in those places and the Court of Appeal came with a decision nullifying the election in some of those places, ordering that certain elections be repeated, or that a by-election, a supplementary election should also be conducted in some of those places. But lo and behold, when those cases get to the Supreme Court is of the other opinion, is of the other decision. He is saying that those governors should continue. Why, as the Supreme Court said, I have very strong suspicion, very strong suspicion, that the Supreme Court is only being slave to precedent. That is to say, if we have affirmed this decision in this also case, judicial precedent, and if we have taken this decision in this also case based on these social parameters and whatever, there is no reason whatsoever why we should reverse ourselves in all decisions. And let us look at all those issues. When you look at the Election Petition Tribunal, issues that were canvassed before those Election Petition Tribunal were based on the card readers, were based on electoral violence, were based on non-substantial compliance with the requirement for being returned as a governor in some of those places and all that. And the Supreme Court has set us without number. In earlier decision, before those three other states that we have mentioned, that the card reader, that the register of voters is the primary evidence by which you can determine whether a person has met the requirement by which to be returned as a governor or not. That the card reader or the electronic device that are introduced by INEC and other were merely couldn't be grounds for which an election can be obtained. And then in the area of electoral violence and snatching of ballot boxes and other, the Supreme Court have said, in terms without normal plethora cases and other, that when you are alleging violence, you are alleging crime. And that when you allege crime, you must prove it beyond reasonable doubt. Within the 180 days, that people have to prove their case before the Election Petition Tribunal. And given the fact that in a place like the Cross River State, for example, where in some of the local governments, you had more than 4,200 and something polling units, will you be able, within the short space of time of 180 days, be able to prove if you only prove that electoral violence have taken place in all those places? And if you do prove that violence, ballot snatching and other have taken place, could it be said that it has taken place in all the different polling booths that you have in those places? If you are unable to prove that it took place in all the different polling booths and other, the Supreme Court is likely to be reluctant to give you judgment.
So there's a difference between judgment and justice.
Yeah, there isn't much. There isn't more. The only difference is that our courts don't base their decisions on hearsay evidence. They don't base it on mob action. What you said played out on the electronic media, on the TV, on the radio and television and other. Most times, the Supreme Court will just look at that as a hearsay evidence. As hearsay evidence, as a kind of mob reaction. Because if the court were to be pandering to what is happening on the streets, then the dangers are that the evidences that are put before the courts will not matter anymore. The court just becomes a place, a kind of a theater or a kind of palace court in which the obas or peace and the palace take a decision based on whatever tissues of evidence their citizens are able to lay before them. And there are ground rules when you are proving evidence in the court of law. There are ground rules. Except you abide by those ground rules or you go by those procedures and other, the courts are not likely to find for you. I have my opinion as whether the Supreme Court is right in being slave to precedent or not. Because like I said, so many times too, like erudite jurists have told us that if when another person is sitting in a court of law where a trial is going on, and this ordinary person is not a lawyer, at the end of the day, when the decision is given, when the judgment is given, said, I think judgment has been, I think a fair trial has taken place. I think justice has been done in this matter. Lord Denny said that is what justice is all about. But when an ordinary person that is sitting in the court comes out the decision and comes out with the opinion or the feeling that I have sat all through these trials and all that, and I don't think judgment has given the decision. I don't think fair justice has been dispensed in this matter. Then you have not gotten justice. So this is the way we should look at the Cross River State thing. If the Supreme Court had not been a slave to precedent, if the Supreme Court had realized, if the Supreme Court had realized that, look, anything that is going to give us a free and fair election, such as the card reader, anything that is going to rein in our highlights, who will want to win election by all means, anything that is going to dissuade somebody who will frustrate the use of technology to arrive at a free and fair election, we are not going to side with those persons. We are not going to give a judgment that will aid such persons in the future. I am sure the Supreme Court would have come off with a better decision. And I also say this, that the Supreme Court, in my humble opinion, appears to be wrong in not looking at the card reader issue, for example. Because that is where the controversy seems to be coming from.
But the judges have to base their judgments basically on the provision of the Constitution.
I agree. But when you are giving your decisions according to the Constitution, you must marry it with the ingredients of evidence, the tissues of evidence that presented before. I'll give you one example. When somebody is put in the witness box, he gives his evidence in chief. The opposing lawyer will cross-examine. In the process of a cross-examination, when questions are being fired at him, the judge or the panel who is looking at the witness will be looking at his demeanor, his reaction. When cross-examination is taking place and the witness is telling lies, the justices or the judge is able to see through some of these things. Those are some of the tissues of evidences that he marries with the principles of law to arrive at the decision. Sadly, when matters go to the Court of Appeal, when they go to the Supreme Court, they don't have the opportunity of seeing the demeanor, the posture, the reactions of the witnesses in the witness box when questions are being thrown to them. It is just the cold letters of the records that are put before them that they base their decisions on. And then the precedent that are taking place in the past, that if this has also happened, if 2 is added to 2, then what you should get is 4, not 5, not 6. So that is where the problem lies. So I think the Supreme Court, instead of saying that the voters register is the primary evidence that's required to use to prove whether there has been substantial compliance in an election or not, I think they should have also taken issues, whatever INEC has, whatever directives, whatever policies, whatever program that INEC has put in place to ensure that we get a free and fair election. The Supreme Court should have considered it as a kind of bylaw or a subsidiary legislation, which they should have taken alongside what is provided for in the Constitution, what is provided for in the Electoral Act, to arrive at whatever decisions they give. Because what they have simply done today is as if the Supreme Court justices are living in the cloud, that are not living in this society, that they don't know what our politicians are capable of doing when it comes to trying to win an election in whatever forms they could win it.
But if they were to do that, wouldn't there be a conflict of the interpretation of the Constitution?
No, I don't think so. The reason I don't think so is this. Look at what happened in the Rotimi Amechi's case, for example. One of those one of those justices who sat on that panel, I said, look, wondering about that. He said, look, we took that decisions in order just to tame the excesses of our political allies. So if they were able to do that in the Rotimi Amechi's case, I don't see why they should not have been able to do it in this instance. You also remember that in 1917,
who became governor without being elected?
Without subjecting himself to another. You will also remember that the two-third majority, I think that was 1979, when Chief of Emir Awolowo and Alhaji Shehu Shagari had this electoral tangle as well. At the end of the case, Supreme Court said, look, two-third of 19 states of Nigeria should not be 13, it should be 12 two-third or thereabout. And they also went ahead and said that this our decision should never be cited in future as a precedent. That tells you that the Supreme Court itself is concerned about the generality of what is happening in the society in order to ensure equity, fairness, and more importantly, peace and security in the society. Any decision that is going to lead to absurdity, the Supreme Court ought not to have given it.
All right, the publicity secretary of the APC in Lagos State wrote an article. It's online everywhere. I want to read excerpts of this. Right. He said he tagged it "Danger as Corruption Creeps into the Supreme Court of Nigeria" by Joe Igbokwe. I fear the judges are using their excessive powers to play to the gallery, and this must be thoroughly investigated. I suggest we investigate their earnings, their investments, and bank statements here and abroad, because of course they are Nigerians as well. Statements like this, and then the APC national chairman said something like that after the Supreme Court judgment on the Rivers State election, though later on he said he didn't say the judges of the Supreme Court should be investigated. Investigation now over the Supreme Court judges.
Honestly, I think he's been too presumptuous. I've been presumptuous in the sense that when partisans give opinion on issues, we have to be very wary of such opinion, in the sense that when the same Supreme Court also gave judgment in favor of the governor of Ogun State, Oyo State, Lagos State, and all that, you find out that the PD people cries foul. Now that the decision is not in favor of the APC, they are also crying foul. And if you have listened to Chief Ole Olanipekun over there, he has said we should tarry a while and wait a little while to see
February 15th.
What the decision, what the ratio, so to say, on what parameters, what were the issues that the Supreme Court based their decisions on. Until those things are that, it might be too early to start jumping to conclusion that the people in the Supreme Court, the justices in the Supreme Court, were compromised to arrive at the decision that they arrive. I do agree that, like human beings, they are prone to make their mistakes, and in making these mistakes, it could sometimes be very, very expensive and costly. Because what has happened in the River case, in the Akwa Ibom State and some of these other states, is giving ammunition to whoever may want to compromise the sanctity of elections in the future. Whereas if the decisions had been otherwise, it will have the capacity to rein in the excesses of our political ally when it comes to winning election
Let's
petitions.
win at all costs and go to the court to validate
but
it.
This also brings us back to certain issues. When we are trying to solve one problem, we always run into some other problem. You and I will remember that in the past, election petitions were allowed to go on for 3, 4 years sometimes. Look at that of Oyinlola and Rauf Aregbesola. Oyinlola had even nearly completed the second time, remaining about 6 months before the decision came from the election petition tribunal, and then said he didn't win the election. That was Rauf Aregbesola that won. It was to curb that kind of a mischief that the lawmakers went and made the decision that, okay, all election petitions must be dispensed with within 180 days. That has thrown a lot of responsibility and obstacle to whoever is challenging the elections of any governor or anybody for that matter. Because if you have a whole state to deal with thousands of polling booths scattered all over the places, and with the kind of state, Akwa Ibom and some of these places and other, how will you in fairness be able to put forward enough evidence and prove your case beyond reasonable doubt within the 180 days?
But one would have thought that
these are the obstacles that people who approach the election petitions for the upturning of any elections are facing now. That's the challenges that they are facing. The time is just too short for you to be able to lay bare whatever things you want to prove beyond reasonable doubt within the 180 days. And the lawmakers themselves have not been too responsive. Because I will remember that when the Electoral Act was being drafted and other, there were issues whether to embrace electronic voting system or not to embrace it. If we have a lawmaker that is responsible to the yearnings and aspirations of modern technology, I am sure this controversy that we have had on the card reader thing wouldn't happen there. The parliament would have quickly incorporated that into the election, the Electoral Act for the 2011 election. But because our allies are not interested in a free and fair election, they made sure they shied away from embracing this electronic voting system. Most of them, they know that if elections are done the way and manner it should be done, deploying the necessary technologies and all that, they probably wouldn't have the opportunity to get to where they are going.
We have to take a break at this point. We'll continue with the discussion in a moment. Stay with us on TVC Breakfast.